Springing from our people's struggle for respect of human dignity, our 1987 Constitution mandates the protection of civil liberties, especially of the poor and the marginalized. As all PHILCONSA members must know, the Charter is promotive of social justice, responsive to the role of women, protective of labor, cognizant of the rights of indigenous cultural communities, and respectful of human rights. It is so protective of human rights that it granted the Supreme Court quasi-legislative powers to, and I quote the Constitution, promulgate rules concerning the protection and enforcement of constitutional rights, unquote. Consequently, when pitted against the enormous powers of the state and of governmental institutions, individual liberties, whether civil, political, or economic, must be fully safeguarded by our courts. Reasoning along these lines, I took the occasion to emphasize the essence of social justice in Ang Bagong Lipunan versus Ang Bagong Bayani OFW Labor Party versus COMELEC in this language, and I quote, "Crucial to the resolution of this case is the fundamental social justice principle that those who have less in life should have more in law. The party list system is one such tool, intended to benefit those who have less in life. It gives the great masses of our people genuine hope and genuine power. It is a message to the destitute and the prejudiced, and even to those in the underground, that change is possible. It is an invitation for them to come out of their limbo and seize the opportunity," unquote. Any case in favor of restrictions on fundamental rights comes to the courts with, quote, "a heavy presumption against its constitutional validity," unquote. Because those limiting freedom of expressions are particularly suspect, they must be subjected to strict scrutiny. Laden with the presumption of invalidity, they are indeed difficult to justify. Recently, the court was called upon to interpret political rights arising from new scientific methods of measuring public perceptions, namely public opinion polls. In ABS-CBN Broadcasting Corporation versus Commission on Elections, a decision I had the honor of writing, the court emphatically explained that, and I quote, "when faced with borderline situations in which the freedom of a candidate or a party to speak or the freedom of the electorate to know is invoked against actions allegedly made to assure clean and free elections, this court shall lean in favor of freedom," unquote. This new ruling, recognizing public opinion polls as a species of the freedom of expression, was reiterated in Social Weather Stations versus COMELEC. Here the court stressed that, and I quote, "because of the preferred status of the constitutional rights of speech, expression, and the press, a law forbidding the publication of free election surveys is vitiated by a weighty presumption of invalidity," unquote. Calls to protect freedom of expressions from undue state restriction have reverberated throughout our nation's history, and the court has always been there to ensure a free market of ideas. Since 1918, in United States versus Bustos, to the recent election exit poll cases I cited, the court has stood as a dependable guardian of free speech and expression. To reiterate, in cases involving civil liberties, I firmly believe that the scales should weigh heavily in favor of the people, especially the poor, the oppressed, the marginalized, the dispossessed, and the weak. But in conflicts over issues affecting prosperity and development, I respectfully submit that deference must be accorded the political branches of government. The Constitution itself is a testament to these principles. Section 1 of Article 8 imposes upon courts the duty, not just the power, not only to settle actual controversies involving rights that are legally demandable and enforceable, but also to determine whether there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of government. This is very important. This is what we call the certiorari power of the courts. However, the duty of courts to strike down grave abuse of discretion does not, as a general rule, include unnecessary meddling in matters of economic policy. On these issues, I believe that courts should lean in favor of the government. Thus, they will not pass upon the merits or wisdom of trade liberalization and economic globalization as economic policies. These are matters that the people have left to the President and Congress to evaluate and decide. To quote from Tanyada versus Angara, a decision I also had the honor of writing, and I quote, "As to whether the nation should join the worldwide march toward trade liberalization and economic globalization is a matter that our people should determine in electing their policymakers. Let the people, through their duly elected officers, make their free choice," unquote.